You still have the surveillance tape, is that correct? Are you allowed to share that with the country?
Absolutely, Sean, at the right time.
After the FBI searched Mar-a-Lago, there was a drumbeat of conservative calls for releasing the tapes. What they meant by that was the surveillance footage of plainclothed FBI agents executing their search warrant at Mar-a-Lago on August 8th. We still do not have that footage. Trump and his people never did release it, at least not yet. There were reportedly concerns in Trump world that releasing that tape might show the sheer volume of materials that federal agents seized. But as of this afternoon, we do have the heavily redacted affidavit for the search warrant used to conduct that August 8th search. And on page 2 of the affidavit, you see this. The FBI laying out the reason they needed to check Mar-a-Lago after Trump turned over 15 boxes of documents in January. Quote, there is probable cause to believe that additional documents that contain classified national defense information remain at the premises. There is also probable cause to believe that evidence of obstruction will be found at the premises. Evidence of obstruction? What could that be? Well, number one, on June 3rd, after a visit from federal prosecutors, Trump's lawyers Christina Bobb and Evan Corcoran said, nothing to see here, folks. There is nothing to see here. Corcoran prepared a statement to the DOJ claiming that all the classified material had been returned, and Christina Bobb signed it, according to the New York Times, which cited two people familiar with that meeting. And then here's number two. The DOJ, unconvinced by Trump's lawyers, subpoenaed Mar-a-Lago surveillance tapes in late June, not the tape that Eric Trump was talking about. This was a surveillance tape from earlier, one that reportedly shows people moving boxes out of Mar-a-Lago and the storage room around the same time that the DOJ was asking if there were any more important documents down there at Mar-a-Lago. The tapes also reportedly show boxes being stuffed into different containers, again, around June 3rd, when Trump's lawyers were saying essentially, nothing doing, you have everything already. Of course, today we know that that is not true at all, and it matters. The Times reports, quote, that June 3rd statement, the one from the lawyers, that is, along with visuals from the surveillance camera footage of the property and witness interviews were said to be part of the concerns among investigators about obstruction. Joining us now is Barbara McQuade, former United States Attorney for the Eastern District of Michigan. Barb, thanks so much for joining us.
Oh, glad to be with you, Alex.
So let's talk about these sort of two elements as it pertains to obstruction. The first is the surveillance footage. How meaningful is that in the potential charge of obstruction? This notion that there were people moving material around Mar-a-Lago around the same time that the government was asking, hey, do we have everything down there?
Yeah, you know, what's interesting about the charge that is identified in the search warrant affidavit, it's a particular type of obstruction of justice. It's 18 U.S.C. Section 1519, which specifically refers to concealing of documents. It's not like witness tampering or some of the other kinds of obstruction statutes. It's specifically concealing of documents. And so, as you just described, moving around some of these documents during a time when there has been a great deal of back and forth about what they have and what they don't have and what they need to return does suggest that there could be a suspicion or even probable cause that they are concealing some of the documents that the archives wants back.
It's worth noting that the DOJ is seeking the Mar-a-Lago footage again. This time the footage, I believe it's either after the raid, but it's after that sort of initial tranche of surveillance footage from June 22nd, right? There's like a period of several weeks before the FBI searches Mar-a-Lago. And I believe the DOJ is looking for surveillance footage of that period, mostly the month of July. What does that tell you?
Well, it does suggest they had to have some reason to know that there was something amiss that they wanted to see might have been revealed on that surveillance video. So what it says to me is perhaps there is a witness within Mar-a-Lago, one or more witnesses, who have indicated to them in witness interviews that people were going in and out of those rooms or moving some of those boxes. It's also noteworthy, Alex, that in the affidavit we saw today, they believe that they had probable cause to search not just the storage room, but also something known as the residential suite. I assume that's where Trump lives. Something called the Pine Room and something called the 45 office. And so it looks like from those words that those boxes were moved and scattered around other places in the residence. And so even if they had a padlock on the storage room, there's certainly grave concern about them being stored in other places in the residence. And so it seems like there must have been witnesses providing information so that they knew to look on this surveillance video. And perhaps it was the surveillance video that revealed some of the things that appeared in that search warrant affidavit.
What about the letter signed by Trump's attorney, Christina Bobb, drafted by his other attorney, Evan Corcoran, saying effectively nothing to see here, folks? This was a letter sent to the DOJ in June. How concerning is that when you're looking at an obstruction charge?
Well, rule number one for aspiring lawyers: if Mr. Corcoran writes the draft, maybe Mr. Corcoran should be the one who signs it, and not another lawyer, Christina Bobb. If those lawyers believed that that was true because Donald Trump or someone else told them it was true, then perhaps they don't have any liability. If they knew that they were continuing to retain documents and representing in writing that all documents had been returned, they have a very serious problem of obstruction of justice, as we just discussed. That is a 20-year felony. Now, it could be that they were unwitting agents, that someone told them to make that representation. If that someone is Donald Trump, then he is also liable, or it could be liable, for using them as unwitting agents to make his own statement. If he knew that that statement was going to be passed on to the Justice Department, then he could be guilty of that offense.
The last thing I'll just bring up as we talk about his crackerjack defense team is the fact that today was the deadline, I believe. The legal team representing Donald Trump, today was the last day they had to file their papers requesting a special master, a sort of independent third-party review of the materials seized in early August by the DOJ. And according to the Trump-appointed judge, they did it wrong. They did not file that request correctly. Do you have confidence in Donald Trump's legal representation at this juncture?
Well, the document they filed on Monday was so amateurish. It was in the wrong court. It didn't allege a cause of action. They failed to provide service. They didn't explain why it was unrelated to another case. And so, no, that is some very shoddy lawyering. But it seems that he's having a difficult time finding someone to represent him who may be able to handle this in a more professional manner.
The understatement of the year. Barbara McQuade, former U.S. Attorney for the Eastern District of Michigan. Thank you for your time and expertise this evening.
Thanks, Alex.